All right, the court, and I guess this is for one case. Court is calling 2024 CR 4295 State versus Luis Beltron. Can I have parties approach and announce for the record?
Arlene Day, the defendant.
All right, and are you?
And here we go, folks. The case of Luis Beltron kicks off. Notice how calm he sounds now, but keep watching, because things are about to get legally messy.
Mr. Beltron?
Yes, Your Honor.
All right, in defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance under the authority of Texas rules.
Classic move here, challenging jurisdiction. It's like saying, hey judge, you don't even have the power to hear this case. Problem is, in criminal law, that argument rarely works. Why? Because once you're indicted for a felony in the right county, the court's authority is pretty locked in.
A civil procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third-party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Bexar County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the Penal Code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris.
Important moment here. The judge reminds Beltron an indictment isn't proof you did anything wrong. It's just saying there's enough smoke to check if there's a fire. Think of it like being sent to trial, not being found guilty.
Harris County, then I wouldn't have any jurisdiction over it. Do you understand? All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, and it has to be allegations that it happened in Bexar County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the Penal Code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court that's in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right. Thank you. And then we have...
Excuse me, did the court take judicial notice of the indictment in this case?
Yes.
Make its ruling? Okay.
Yes.
The
next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of couple.
Here's the real kicker. Aggravated robbery isn't just taking something. It's taking something with force or threat, usually with a weapon. That's what makes it a felony, And that's why the state's pushing hard here.
With the first paragraph, that the court his position was the court didn't have jurisdiction. The court just ruled that they did, that then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right.
Did I get that right?
Yes.
Okay.
All right. So state, you want to address the issue and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right. So if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the Penal Code and the Code of Criminal Procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right. So Mr. Beltron, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the Penal Code, and there's a list in the Penal Code of all the crimes, and aggravated robbery is one of those crimes that's listed in the Penal Code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the Penal Code. You understand?
And here's where Beltran's legal theory crashes. He's mixing up civil and criminal law. The Seventh Amendment protects jury trials in civil suits, like lawsuits over money. But in criminal court, whole different ballgame.
So, do you understand? You gonna have any questions about the court's ruling? All right. If there's something you don't understand, let me know. All right. And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right. So number 3, defendant is erroneously charged with an abstract offense. C, I don't know, I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no-fault immunity third-party benefit in violation of the 7th Amendment. All right, do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to being a third party brought in here without abstract subject matter jurisdiction, and the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right. State, do you want to respond?
Judge, regarding, I guess, the 7th Amendment applying in the case, or, okay.
Yes.
That is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
All right. So the 7th Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial. And if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say, explain it to me. You're saying district court is criminally attempting to receive an unauthorized, colorable, no-fault immunity. What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary. for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand? Do you have any question about that? All right. So then,
This is wild. Beltron wants to cross-examine the entire state of Texas. Imagine putting 30 million people on the stand. The judge quickly sets him straight. You don't question the state itself. You question the witnesses they bring in.
the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 U.S.C.S. 841. This court now under federal questioning under Title 28 U.S.C. 1331, light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm going to ask him to explain it.
All right, if you could explain that to me, Mr. Beltran.
I guess what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff, and they're the ones that are pursuing to prosecute me, which is they're the one of third party.
Okay.
And I don't third party. I'm not sure how that works. I know how civil suits, and I know it's criminal law, but I know that. I mean, how can I cross-examine the state of Texas? How can I?
So let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual.
Yeah,
if it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bexar. So that's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be.
So at the end of all this, the judge denies Beltran's motion. Translation: the trial goes forward, and all these jurisdictional arguments get tossed aside. The real fight is still ahead when evidence and witnesses come into play.
Any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bexar County. They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You understand?
I understand.
All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next? Are there any other things in here? Because some of it repeats itself. Were those the main points?
Other than anything.
Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different?
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls. Okay, so that will be denied.
There is it appears to me that there was like 3 separate documents stapled together. Is that the way it was received?
Yes.
There is the The next one, which is exhausting administrative relief.
Mhm.
My client is